Yes.
Lord, this revision application is time barred by 69 days, my lord. By the order impugned, my lord, maintenance of rupees 1,500.
1500 के लिए आप आ गए? हाँ,
My lord, 1,000 more, my lord, to a child, my lord. Because he was always ready, even he is still ready to keep her, my lord.
this is a frivolous application. This is a frivolous application. 1500 रुपये आप नहीं देना चाहते हैं वाइफ को?
1,000 और है, 2,500।
हाँ, 2500 भी है। 1000 किसके लिए है? माइनर डॉटर के लिए।
हुजूर,
क्या बोले आपको
हम हुजूर रखना चाहते हैं।
आपका नैतिक, आपका लगता है बिल्कुल जैसे नैतिक पतन हो गया।
तो हुजूर, अगर हुजूर का नोटिस कर दिया,
कानून तो अपनी जगह है, मोरालिटी भी कुछ चीज है ना।
अगर हो सकता है
एंड कानून के नजर से भी अगर मोरालिटी देखा जाए, कॉन्स्टिट्यूशनल मोरालिटी की जो बात करते हैं हम लोग, तो इवन कानून ने के नजर में जो है आपका नैतिक पतन हो गया, क्योंकि आप इतना 1,000 रुपया एक माइनर डॉटर को नहीं दे रहे हैं, 1500 रुपया अपनी वाइफ को नहीं दे रहे हैं।
एक का कहना है कि किसी तरह से हमको वाइफ
कुछ नहीं, आप
ये रखना चाह रहा है, बस इसका इतना
चाह रहे हैं। रखना चाहना कोई बहस नहीं हुआ इस तरह के केसेस में। आप अपनी वाइफ को अगर टॉर्चर कर रहे हैं, आपके क्रूएल एक्ट के चलते आपकी वाइफ नहीं रह पा रही है आपके साथ, तो उनको अधिकार है अलग रहने का, तो और वो आपसे मेंटेनेंस लेंगी। यही लॉ है।
लॉ तो है वहाँ,
तब
हम कुछ नहीं करना है।
बोलिए, हम कुछ और लगाएंगे आपके ऊपर। चॉइस इज योर्स। आई एम रेडी टू हियर योर मैटर, बट prima facie I find that this is a frivolous application.
विथड्रॉ कर लेते।
In the name of pendency of this application, you are withholding the entire money.
विथड्रॉ कर लेते हैं।
लिखिए, after some argument, Learned Counsel for the petitioner seeks permission to withdraw this application unconditionally. Permission is granted. Application is dismissed as withdrawn. Next, Learned Presiding Officer, Family Court, Gopalganj, shall proceed to realize the entire amount in terms of the order dated 9/1/2018, expeditiously and in accordance with law. Full stop. The petitioner shall also pay a litigation cost of rupees 10,000 to his wife and minor daughter, which will also be realized through the process by the learned court below. Full stop. Application stands disposed of accordingly.
Item number 20, Devendra Kumar.
Yes.
Learned trial court has refused to grant maintenance in favor of petitioner only on the ground that the petitioner has entered into a इकरारनामा, और उसमें इन्होंने कहा कि हम इनके ऊपर अब कोई क्लेम नहीं करेंगे, अपना मैरिज डिसॉल्व करते हैं, और मेंटेनेंस सिर्फ बच्चों के पक्ष में अवार्ड की।
आपने क्या लमसम अमाउंट लिया था क्या?
नो मिलोड।
कहाँ है वो इकरारनामा?
दैट इज नॉट ऑन रिकॉर्ड लॉर्डशिप।
Where is the इकरारनामा?
ऑर्डर में हुजूर डिनायल हमारा सब जगह आया है।
नहीं, that is not the only thing. What you are not saying is that you had left your ससुराल on your own volition, and that is the reason you forgo the claim for maintenance.
एक्चुअली लॉर्डशिप जब 498 की सुनवाई है कि
मुझे नहीं मालूम, पैराग्राफ 11 पढ़िए इम्प्यून जजमेंट का। Said only half thing.
Lordship, in view of Exhibit 1, it is clear that petitioner has herself left her sasural, and for this she is responsible. She has also broken her relation with OP as a wife, so she is not entitled to get any maintenance from the OP. But there is evidence that the petitioner has got a minor daughter from wedlock with OP, and OP has not filed
बिल्कुल
any.
सही ऑर्डर,
Lordship.
perfectly justified. डॉटर को दे रहे हैं कि नहीं?
दे रहे हैं।
दे रहे हैं ना?
एक भी पैसा जो राज तक नहीं दी,
डॉटर को नहीं दिया है?
एक भी
भाई
पैसा
साहब, अभी कल बात हुआ है तो अभी 1-2 महीना पहले तक का नहीं किए हैं, बाकी हम किए हुए हैं, हम रिकॉर्ड पे ला देते हैं।
लादे में हुजूर रिकॉर्ड।
देखिए, heard learned counsel for the petitioner and learned counsel for the opposite party. Petitioner in this case is aggrieved by and dissatisfied with the order dated so and so, para 1. Next, learned counsel for the petitioner has though assailed the impugned order on the ground that the petitioner would have a statutory right to claim maintenance under section 125 CRPC, comma, client counsel is unable to come out of the findings recorded by the learned principal judge family court Vaisali in paragraph 11 of the impugned judgment. Full stop. The learned principal judge has recorded that the petitioner had herself left her sasural, which is evident from exhibit 1, and for this she is responsible. Full stop. She had broken her relationship with the opposite party as a wife. Full stop. In the facts of this case, where it was evident from exhibit 1 that the petitioner had refused to live with the that the applicant wife had refused to live with her husband, and she had given it in writing and had broken all relationship, comma, she would not be entitled to seek maintenance at least under section 125 CRPC. Full stop. Give me CRPC. Section 125 CRPC. ऐसे कीजिए, subsection 5 of section 125 CRPC clearly stipulates that on proof that any wife is living separately by mutual consent, the order, if any, of maintenance shall be cancelled. Full stop. Full stop. By virtue of subsection 4 of section 125, in similar circumstance, she would not be entitled to receive any allowance for the maintenance. Full stop. This court therefore finds no reason to interfere with that part of the order, impugned order, which has gone against the applicant wife. Full stop. Next, so far as the maintenance allowance awarded to the minor daughter is concerned, comma, the same is not under challenge by the husband of this petitioner. Full stop. It is stated at the bar by learned counsel for the petitioner that the said payment is not being made to the minor daughter, but learned counsel for the husband as opposite party in the present submits that payments have been made regularly
इधर कुछ पेमेंट बाकी होगा इस इसके
save and accept that payment of last
few month
3-4 months,
मेजोरिटी एग्जैक्टली हम नहीं बता सकते लेकिन कुछ मंथ का बोलेगी बाकी है
मंथ का ही ना बाकी है, साल का नहीं है ना।
एज पर
हमको जो
कंफ्यूज करते जा रहे हैं आप।
नहीं कंफ्यूज नहीं कर रहा हूँ
हमको जो रात
टेलीफोनिक इंस्ट्रक्शन ये था कि हम पेमेंट कर रहे हैं कुछ
Claims
मंथ का
that
नहीं
the payment and save and accept that the payment of last few months have not been made. Full stop. The statement made on behalf of OP number 2, on behalf of the husband opposite party, seems to be tentative in nature, as learned counsel representing him having said initially that payment has not been made only for few months, seems to be lacking confidence in making further statements giving much clarity on this issue. Full stop. Next. Let the Principal Judge Family Court Vaisali enforce the order against the husband as opposite party with respect to the payment of maintenance allowance to the minor daughter. Full stop. If it is found that the husband, the SOP, has not been paying the maintenance amount to his minor daughter for a substantial period and the outstanding is of more than 6 months as on today, he will be liable to pay the said amount with interest thereon at the rate of 12% per annum with a cost of ₹10,000 to his minor daughter, which will be realized through the process of court by the learned court.
Item number 21.
Why 1 week? Why 1 week?
ऑफिसर जो प्रेजेंट है सीनियर काउंसिल नहीं है,
थोड़ा जोर से बोलिए ना।
सीनियर काउंसिल नहीं है
सीनियर काउंसिल इसमें
जी।
इस केस को नहीं बहस कीजिएगा आप।
मेरा नहीं है तब
सीनियर काउंसिल कौन है जिनका एडवोकेट ऑन रिकॉर्ड नहीं है?
नफीसुज्जुआ
वेयर इज हिज एडवोकेट ऑन रिकॉर्ड?
नफीसुज्जुआ है।
देयर आर 2 एडवोकेट्स इन दिस केस। आप नहीं है इसमें। वेयर इज द अदर एडवोकेट?
आउट ऑफ स्टेशन है वो।
तो ठीक है, अगर केस को इसी तरह छोड़कर आउट ऑफ स्टेशन चले जाते हैं तो आई विल डिस्पोज इट ऑफ ऑन द बेसिस ऑफ रिकॉर्ड्स।
लास्ट टाइम
These are maintenance cases pending since 2018. Neglected women's का, children का मैटर है, उसको आप इस तरह से डिले नहीं कर सकते।
लास्ट टाइम से
लिखिए, no one appears on behalf of the petitioner. Full stop. A prayer for adjournment has been made through a proxy counsel. Full stop. With much reluctance, this court is passing over the matter, giving an opportunity to the learned counsel for the petitioner to come and argue the matter tomorrow. Asked over for the day.